Amendment 43, Lord Davies of Stamford.
My Lords, it's not very easy to generate a great deal of excitement at this time of night about any item of jurisprudence, but I rise to speak about the Francovich principle, which actually is extremely important. Both as a general principle, I think there is no more important in our legal system, and as an instrument driving ever better government, ever better standards of governance and standards of output by the public sector. Let me explain briefly. The Francovich case, as I think noble lords know, all noble and learned lords will know very well. There's a piece of jurisprudence dating originally from 1991. It's been with us for 25 years. It's become very much part of the scene, part, I think I can, without exaggeration, can say part of the political and legal culture that we've created in the European Union over that time. And it's been extended by jurisprudence, so it covers both states and public authorities and agencies and local government, and it's been extended also more recently to cover the private sector. And what the principle says is that where an individual or corporate body or a state body has been in breach of union law, and individuals, corporate or private individuals, have suffered thereby, they will have the remedy that the courts concerned will be able to impose damages proportionate to the losses incurred by those who have suffered by the bad governance concerned. And when I say it's a very important principle and a very important pragmatic instrument, let me explain. It's a very important principle because the principle surely here is that the state itself must be subject to the law. If I go out and break the law, I can be arrested, charged, and eventually fined or even sent to prison in certain cases, and I can certainly be sued for civil damages, for negligence, for breach of the law, etc. If, however, the state bodies are immune from law, then you have a very different relationship between the citizen and the state to the one that we always like to think exists in a constitutional democracy. So that is a very important principle, and it's a principle which will cease to be enshrined in law if we don't amend the bill as it currently stands. Now, the pragmatic instrument, the valuable pragmatic instrument, which I've also referred to, is simply that the existence of the Francovich judgment, and I think it's been cited by some over 300 cases since the library told me, and has played a major part in many decisions. And if there was more time, I should like to digress on the bad planning cases, the planning decisions have been reversed, or the beaches or the rivers that have been cleaned up as a result of the working of this principle. The principle does drive better government the whole time. Now, I dare say the government, in their contribution to the debate, will say, but that doesn't matter because when we leave the Union we can fall back on judicial review. And judicial review, of course, is a creation not of European jurisprudence but of our own jurisprudence, and it's a very valuable principle, very valuable achievement over the last 50 years. Not, in my view, as I've already argued, quite as important or as valuable as the Francovich principle, but nevertheless it is a splendid thing. There's a big, big difference between judicial review and Francovich. Because under judicial review you can't get any damages. You can spend, 3 million, 5 million. No doubt noble and learned lords will tell me any amount of money you want by running the case, but you won't actually get the damages which you get under a Francovich case. And all of us who've been involved in government know that there's nothing more terrifying for any minister than to be the prospect of being exposed as being responsible for the loss of the money of his department. And indeed, the life expectancy, the political life expectancy of any minister finding himself in that position is likely to be a matter of hours rather than days. So the risk of having damages awarded against one is a very real, very real threat to anybody in a position of responsibility, chief executive or local council, chief executive of an agency, minister or whoever, and it makes anybody stop and think extremely carefully. So that is what we're talking about in this particular bill. Now, this particular amendment. Now, going through this bill, I think all of us have a great difficulty. We have a choice to make, and I don't think any of us probably completely clear about how we should make it. Hopefully we want to take a decision by the end of the time when the bill emerges from a report, but it may take a little while yet. And the choice is this: do we believe the bill, or do we believe the government? If we believe the bill, all these rights are disappearing. These rights, these remedies, these protections are disappearing. That's what the bill says. The bill says, Francovich has been abolished, and that's what the wording of the bill before us says, unambiguously, quite clearly. So there in other parts of the bill, as we've seen today and on other occasions as the committee stage started, it's the same story. I mean, we were talking earlier on about family rights and so forth, and labour rights, and it looks as though some of those are not being protected, or even animal rights not being carried forward, at least in the same terms, and the wording being changed and softened, and so on and so forth. These subtle ways in which rights and protections are being withdrawn. That's what you get from reading the bill. What you get from reading the bill is actually that, what is more, the government continually tell us that all this bill does is simply to make sure there's no legal uncertainty at the time of Brexit and simply carry forward the retained law into British law. In actual fact, there's an agenda in this bill which is quite blatant to anybody who reads it. It's not a hidden agenda, I mean, it's quite obvious, which is a kind of power grab by the executive branch at the expense of the citizen. The Charter of Fundamental Rights is going. That's clearly a loss to the citizen, a gain to the executive branch, who can't have the Charter of Fundamental Rights played in aid any longer against him. The most worrying, most concerning aspect of this, of course, is the Henry VIII clauses, which we've yet to come to, which is an extraordinary power grab by the executive at the expense of Parliament. And we have here in Francovich, over the Francovich issue, again, a power grab by the executive branch who want to abolish this, because of course it's something which is a trial and a problem for the state, for the executive branch. They have to perform, or else they have to pay up and get humiliated. So that is what we see. It's very difficult to know whether that is the truth, or whether what is the truth is what we heard from the noble Lord Duncan in the last group of amendments, which was put very appealingly, I thought, and I'm sure with great sincerity, and that is that no rights are being removed at all. Nothing, there's no weakening, no erosion. I think I quote his words exactly. All the rights and protections are being carried forward. I only hope it is so. But if they are being carried in the case of Francovich, and indeed other cases as well, then let us see that on the bill. Let's remove the ambiguities in the bill, because there's a clear contradiction between what we're being told about no rights and protections being abolished, and the fact that here, right in front of us, I'll quote it if anybody wants, the words before us in the text referred to in the amendment say this particular paragraph is abolished. So which is it? Is it the very alluring picture we've been given by the noble Lord Duncan just half an hour ago, indeed the similar picture given by the Prime Minister in her speech on Friday, or is it the bill? That's the problem. My Lords, I hope that this matter can be resolved very clearly. I hope that the government will tell us, actually, no, we can set our minds at rest. The assurances we've been given override the apparent message of the bill, and if there are any problems or anomalies, they'll be sorted out at a report stage, and among other things, that the Francovich principle will be upheld and preserved. I just make one final point, my Lords, if I may, before I sit down. And that is, I dare say it will be said by the government on this subject that Francovich is not appropriate once we've left the Union, because after all, they won't be part of the Union anymore, and the whole purpose of Francovich is to provide people with a remedy who are disadvantaged by the non-observance of Union law in the European Union. My own view is that we should make sure that those people who currently enjoy, and that's all of us, all our citizens in this country, who currently enjoy those rights and remedies, should continue to enjoy those rights and remedies in respect of the same laws in which they do at the present time. In other words, in respect of retained law. There could be a very reasonable and attractive agenda which would say we should now extend the Francovich principle from a union law or retained law to the generality of law in this country, British law, as I say, English law, Scots law, etc. I would be very much up for that. I'd be very much in favour of it, but I see that A, is slightly complicating the issue, and B, I fear that I should be told that this bill is not the right vehicle. I think that's probably correct, in which to achieve that purpose. But my purpose is to make sure that we continue to have the rights we enjoy today. And if we accept this amendment, we will achieve that.
I'm so sorry.
Amendment proposed, page 16, line 27, leave out paragraph 4, Amendment 43. I must advise the committee that if this amendment were agreed to, I would be unable to call amendments 44 or 45 for reasons of preemption.
For intervening too early. My Lords, for those of us who have real enjoyment in the law, a nice bit of law at 3 minutes past midnight is rather like a comforting, calm, creamy cup of cocoa. But I recognise that not everybody is of the same view. With that in mind, I propose to elide in the remarks I'm going to make comments on Amendment 45, which appears in my name and that of the noble Lord Lucas, and also comments on Amendments 48 and 50, which appear in the same names. That should save time in a few minutes, because I understand we're intending to complete that group as well. These amendments are designed to retain the so-called Francovich principle, and I congratulate the noble lord who's just spoken on summarising the Francovich principle very well. If I may, I'm just going to add a little bit of flesh on it, because I wish to try and tease out of the noble and learned lord, the minister, a response which may provide a welcome response to those of us who are seeking to preserve at least part of the Francovich principle, though I would happily pass to the noble and learned lord the burden of perfected drafting. In the Gina Miller litigation, in which the noble and learned lord and my noble friend Lord Pannick played starring parts, the government in its submissions placed considerable weight upon its intention to enact what was then called a Great Repeal Bill. As the Supreme Court understood it, that bill would, and this is a quotation from the majority judgment at paragraph 4, repeal the 1972 Act and, wherever practical, convert existing EU law into domestic law, at least for a transitional period. Well, surprisingly, in relation to the Francovich principle, there's been no conversion and no transition. And I would ask the noble and learned lord to explain why, if that really is the position that the government wishes to maintain. The Francovich principle is a principle of existing EU law which requires damages to be available where three conditions are met. First, that the rule infringed was intended to confer rights on individuals. Well, I'm sure we'd all applaud that. Secondly, that the breach was sufficiently serious to give rise to a legal action. I'm sure we'd all applaud that. And thirdly, there was a direct causal link between the breach of the obligation resting on the defendant and the damage sustained by the injured party. Well, I'm sure we'd all applaud that too. So perhaps the noble and learned lord would explain to us why he wants to get rid of that principle. To provide a little more explanation for the fascinated non-lawyers here, who I think may just about be in a majority, I always listen with great respect to the government chief whip, especially when he sympathetically allows us to debate these issues after midnight. In Francovich, workers who suffered damage when their employer became insolvent were entitled to compensation under an EU directive which required member states to secure their protection. Since Italy had failed to implement the directive, the individual workers brought a claim before their national courts for compensation from the state for the damage they had suffered due to this failure. And I think we'd all applaud that too, wouldn't we, my lords? State liability is enforced not through the European courts, but through national courts. Thus, the ECJ stipulated that national procedures should determine how state liability is enforced. The procedures for claiming damages from the state before national courts must comply with the principles of equivalence, that is to say, with the procedures available for comparable claims for damages, and effectiveness, to secure that EU law as well as national law is respected. So long as it respects these two principles, the member state can prescribe its own procedures for claims as regards, for example, proof and time limits. So it's hardly imposing wicked European ideas on the national courts, since they are left to enforce the principles concerned. And the Francovich principle has led to some significant legal actions. Perhaps the best known in the UK is the Factortame litigation, which contained 5 cases concerning fishing rights. Now, what's the problem with the bill? Well, the bill is confusing. And here I quote from the summarised views of commentators more expert than I on this particular subject. It is said that Clause 6.1 of the bill removes the right to rely on EU law and obtain a reference to the ECJ after the date of exit. Schedule 1, paragraphs 3 and 4, plainly removes the ability to rely on EU law or utilise the Francovich principle after the date of exit. Plainly, or does it? Because Schedule 8, paragraph 27.3, which all noble lords will have been reading carefully in preparation for this short debate, makes it clear that cases begun prior to the exit date are not subject to the restriction I've described and therefore can continue to rely on Francovich. As was pointed out by Dame Cheryl Gillan in another place on the 14th of November last, the bill is just contradictory in that it allows both the continued reliance on Francovich in cases commenced before the date of exit, but also removes that right. That appears to mean that a litigant in a case started before the date of exit and who has a legitimate expectation that the law will not change retrospectively and that he or she will be able to rely on Francovich will lose that expectation. If I am wrong in that proposition, I'm not the only one who's wrong, and I would like it corrected, please. All litigants have a legitimate expectation to have their cases heard under the rules applicable not at an arbitrary time, such as the date of exit, but at the time of the breach of the law concerned. And this includes EU law at that time if it was applicable, and on the face of it, the right of a reference to the ECJ if they are dissatisfied. The purposes of the 2 groups of amendments is to achieve something much simpler, clearer and more just than the complaints, the conclusion, if the complaints I've described are correct. My Lords, I would respectfully suggest that if a relevant cause of action accrues before the date of exit, the claimant should be able to pursue that cause of action. That would be their normal litigation right, and exit should not retrospectively remove that normal litigation right. As the Withdrawal Bill stands, because of ambiguity, there is a risk that some or all Francovich claims, unless they've already been completed, will be extinguished. Surely that would be an incorrect consequence and an unintended consequence. And plainly, and I will deal with this in a moment, there are some concerns about the potential role of the ECJ. I, of course, will give way to the noble lord.
Well, that was one of the points I was going to make, the continued role of the ECJ. But while I'm on my feet, I entirely understand his points about transitional provisions. But I wonder if he could clarify to the House whether his support will go as far as the noble Lord, Lord Davies, as it were, in having a continuing Francovich.
No, right. I will not go so far as the latter part of the noble Lord, Lord Davies's speech. I recognise that if we leave the European Union, as we are doing, we have to have the transitional arrangements that were promised and which were referred to by the learned judges in the Supreme Court on the basis of the submissions which may well have been made by the noble and learned Lord himself. And so, my Lords, what I would suggest to deal with the ECJ problem is one of 2 alternative results. One is to allow the ECJ jurisdiction to continue for the very small number of cases likely to arise. But I recognise, of course, that that will attract political problems which might better be overcome by a more pragmatic solution. The pragmatic solution is to recognise and clarify that the United Kingdom courts, in dealing with such cases, should apply normal comparative law principles, the sort of things that we as lawyers are accustomed to when we cite, for example, Australian or Canadian cases before the senior courts. This would mean that the courts of the United Kingdom, in dealing with such cases, should have due regard to ECJ decisions on similar and analogous matters. This would fall, as I say, within the ordinary principles of comparative law, whereby the United Kingdom courts give due weight to useful and relevant decisions in other jurisdictions. Thus, we would have at least analogous law applied to the residual Francovich cases. We would have a right to make a claim on the basis of the date when the claim accrued, even if it is not yet quantified and not yet pursued, and the unintended consequences of retrospectivity would be avoided. My Lords, in my view, this would accord with sound legal principle. I would urge the noble Lord, the Minister, even at this late hour, to say that he will return to the House with suitable and welcome government amendments for the clarification and preservation of what are proper bases for action.
My Lords, I rise to support Amendment 43, led by the Noble Lord Davies, supported by Noble Lords Foster and Fawkes, to which I have added my name, but I also support the thrust of Amendments 44 and 45. I will try to be brief in light of the hour, but this amendment aims to ensure that the government must maintain its pledge not to water down rights if we leave the EU. I must say I do not see why the bill needs to explicitly remove the right to Francovich protection, which allows citizens, individuals and small businesses to sue the government for damages resulting at the very least from past breaches of EU law. My Lords, I hope that my noble friend the Minister will reconsider the removal of this protection, which would otherwise take away a key last bastion protection for citizens and small businesses to have some remedy against harm caused to them by government policy. The government says that people will still be able to sue in the UK courts, but in practice this power is not normally exercisable. I have personal involvement in this area and have seen how difficult it is to mount a legal challenge against the government. A judicial review must be launched within a very short time scale, which most ordinary individuals would struggle to meet. When I was helping the 150,000 members of final salary pension schemes, such as Allied Steel and Wire and Dexian, who had lost their entire company pension and part of their state pension as a result of flawed laws which failed to properly protect their pension rights when their company became insolvent, despite being obliged to do so by EU insolvency directive. I had to find lawyers who would work on a no-win, no-fee basis, and even then the government refused to agree not to pursue the claimants for the government's costs if we lost. These poor claimants faced losing all their assets, including their home, when taking the government to court, and most people simply could not realistically take such pressure. It is unreasonable, I believe, to remove the last resort protection that such people would have, which would allow them to appeal to the EU courts under Francovich protection for a ruling which would not face the same costs and difficulties as would be implied by a UK court action against the government. If an EU directive was implemented wrongly and the government has not introduced sufficient protections, despite being obliged to do so, this amendment would ensure that the bill does not remove their last resort to redress, and I hope that the government will agree to this amendment or its own version.
I rise to support Amendment 43, to which I've added my name, and also to support Amendments 44 and 45. But can I just begin with a slight disagreement with the noble Lord Carlile, because I suspect that I am, in fact, in a minority, and that is those of us who are not ourselves lawyers. But I'm very conscious that during the passage of deliberations on the bill so far, we've heard many times that phrase that the bill is intended as a general rule that the same rules and laws will apply after we leave the EU as they did before. And we heard about an hour ago a very powerful reiteration of that from the noble Lord Duncan, who was making it very clear that he believes that is what the government seeks to achieve. And yet that has to be put alongside the continuing concern in the other place and in many parts of your Lordship's House that somehow or other Schedule 1 is providing the government with a get-out-of-jail-free card, an opportunity to have a series of measures which appear at least to curtail some of the legal rights and remedies that we have enjoyed as a result of our membership of the European Union. And a very glaring example of that is the one that has already been raised and well illustrated by Lord Davies, Lord Carlile and Baroness Altmann, and that is contained in paragraph 4 of Schedule 1 in relation to Francovich. And as the noble Lord Carlile has rightly pointed out, that Francovich isn't just some right that anybody who feels slightly aggrieved by the government, their government not properly implementing some piece of EU legislation, can immediately start action. There are three very clear criteria that have to be met, have been already laid out: that there are rights conferred on an individual, that the breach was sufficiently serious, and there is a clear causal connection between the breach and the damage sustained by the individual. But it seems clear, at least to me as a non-lawyer, that if Schedule 1, paragraph 4 of Schedule 1 remains in the bill, certainly no retrospective claims under Francovich will be permitted, and certainly if the proceedings hadn't been started before the time of exit. And in those cases, individuals will lose their ability to claim damages against the state for failure to implement EU laws and directives issued pre-exit. So that would mean that the victim of a government failure to correctly implement an EU law must have started action before exit day, but that will not always be possible, and it would seem to me at least contrary to natural justice. Access to justice, including the ability to challenge the actions of the state before a court of law, is central to the rule of law, and if paragraph 4 Schedule 1 remains as it stands, it seems that access to justice for some people will be denied. Now, my lords, I was in your lordship's house some 10 days ago or so when we heard, during exchanges on the statement on air quality, that the High Court had ruled that the government's air quality plan, designed to tackle nitrogen dioxide in the air, was unlawful. The court ruling said, and I quote them, "It is now 8 years since compliance with the 2008 EU directive should have been achieved. This," they went on to say, "is the third unsuccessful attempt the government has made at devising an air quality plan which complies with the directive and with domestic regulations." And the judge, Mr. Justice Garnham, added, "In the meantime, UK citizens have been exposed to significant health risks." Now, it may be, my lords, that some individuals will wish to argue under the rule of Francovich that they have suffered damage and deserve compensation because of the government's failure to implement the 2008 directive. And without Amendment 43 or some similar measure, such individuals will be prevented from seeking justice unless they submit their claim and have their case underway before exit day. Now, my lords, in the other place, many other examples of potential loss of access to justice under Francovich were raised. And initially there, the minister, Dominic Raab, offered assurances, and I quote, that individuals will not lose their ability to vindicate their rights in court after exit. Now, it may be, and I've no way of knowing, that he believes that to have been the case because of Section 16 of the Interpretation Act 1978, which provides where an act repeals an enactment, the repeal does not, unless the contrary intention appears, affect any right, privilege, obligation, or liability accrued or incurred under that enactment. So the right to claim under the rule of Francovich post-exit would seem to depend on whether or not the bill before us provides an effective and clear contrary intention. And so I would like the Minister, the Noble Lord the Minister, to tell us very clearly whether or not the government believes that Schedule 1, Paragraph 4 provides a clear contrary intention within the meaning of Section 16 of the Interpretation Act 1978. Certainly there are some other lawyers who appear very uncertain about that point. The very helpful briefing, for example, from James Segan of Blackstone Chambers leads me to conclude that seeking justice by arguing there was no contrary intention or that it had been introduced ineffectively would lead litigants into a legal quagmire. So I was slightly heartened when, in the other place, a little later on in the deliberations, the minister changed his tune when pressed by, among others, Conservative MPs Robert Neal, Cheryl Gillan and Sir Oliver Letwin. He told them then that he acknowledged the importance of legitimate expectations and agreed to see if these concerns could be addressed, at least transitorily, by regulation rather than in the bill. So I hope very much that the Noble and Learned Lord, the Minister, can update us on progress on that thinking. And the Noble Lord, the Minister, has already said in relation to other aspects of Schedule 1 that the government are willing to do that. But I would just end by saying I would have thought that by far the better route to securing continuation of the rights under Francovich will be to accept Amendment 43 or something of that like, and ensure that it's very clearly on the face of the bill that when the government says that the same rules and laws will apply after we leave the EU as they did before, it really does mean it.
Will he accept that the right to damages under the Francovich principle is more generous to claimants than the common law principle of judicial review, under which you very rarely have a right to claim damages? You need to prove misfeasance in public office or something similar. So Francovich is more generous. It's my first question. Does he accept that? And does he accept, secondly, that it therefore follows that paragraph 4 of Schedule 1 to this bill conflicts with the government's own purpose in bringing forward this bill, which is to read across all existing rights that are enjoyed under EU law? And if he accepts that, what is the justification for making an exception for Francovich damages?
My Lords, it seems to me that if the government breaks the law, it should be judged on the basis of the law at the time that it breaks it, and that this is not a bill in which the government should seek to advantage itself by averting that principle.
In this subject in a second reading, and in respect to the disputes that arose under the old regime, seem to me to deserve fair treatment. I am aware of instances, in particular of small businesses, where it could lead to a very unfair result and deprive genuine claimants of going to the EU courts. Lord Foster of Bath mentioned the note by James Segan, and it raises the question which perhaps my noble and learned friend could answer as to whether or not, as it currently stands with the Schedule 8, paragraph 27.1 as mentioned, and the Interpretation Act 1978, section 16, there could be action under the Human Rights Act. And that would be politically, far from anything else, unacceptable to see claimants pursuing their claims if there were no Francovich.
My Lords, I look forward to the answers that the noble learned Lord is going to give to Lord Pannick's questions. I have the Amendment 44, which deals with the timing of the Francovich claim, but I can be short. My noble friend Lord Davies of Stamford set out very well what it is we're talking about. The noble Lord Carlile indicated the problems that the government's approach gives rise to. And I think one can look at it this way. At the moment, the bill appears to say that if the government were to commit an act which was unlawful, a breach of union law, before exit day, then the Francovich claim could not be brought except in circumstances where the claim had actually been brought before exit day. I don't see the justification for that. That amounts to whitewashing an unlawful act, and as has been said, and seems to me to be absolutely right, is quite inconsistent with the promise that has been made that we will have the same rights the day after exit day as the day before. So I look forward to the answers to those questions, and this must be an amendment. At least, if it doesn't go as far as the noble Lord, my noble friend Lord Davies of Stamford wants, at least it must apply, as Lord Carlile put it, to accrued rights. Any act which is committed before exit day, which gives rise to a Francovich claim, should continue to do so.
My Lords, I'm obliged. Reference has been made to the Francovich principle. I'm not sure there is such a principle. There is the issue of Francovich damages, which arises from the case that was referred to in 1991. And in order to put that into context, since 1991, and in the 20 years following, there have been 22, possibly up to 25 claims for Francovich damages in the UK courts. So this is not some wide-ranging citizen right or business right for the recovery of damages. There have been very few actual Francovich damages claims. I see the noble Lord shaking his head, but I invite him to study the case law.
The noble Lord says, so why are they so worried about keeping it?
I'm just about to come on to that. You know, I'm obliged to the noble and learned Lord for his patience in that respect. And I will endeavour to deal with matters as swiftly as I can, given the hour. Now, the noble Lord Carlile very correctly pointed out the criteria that applied in determining whether or not there is a claim for Francovich damages. One, that the relevant provision of European Union law was intended to confer rights. Secondly, that there's been a serious failure to implement European Union law, and thirdly, that there is a direct causal link between that failure and the loss complained of. And to that extent, I wouldn't go so far as to suggest that Francovich damages are in some sense more generous than those available otherwise under the common law in this country, particularly those available in the context of judicial review. And to that extent, I have to point out to the noble Lord Davies that damages are potentially available in a claim for judicial review. But having said that, this is not...
Learned Lord give way. I'm most grateful to the noble learned Lord giving way. I think that the noble learned Lord Pannick dealt with that point. In practice, damages are not usually available under judicial review, and the general view of the public is that you have a very small chance of getting damages that way. That's the difference between that and Francovich is very important.
No, with respect, it's not. I have to say to the noble lord that Francovich damages are a rare remedy, as I've already indicated. Damages in the context of judicial review are not so uncommon as the noble lord would suggest, and they are available as a remedy, albeit in limited circumstances. But if I can continue just for a moment. Now, can we begin by looking at the bill against that background? Schedule 1, paragraph 4 is perfectly clear in saying that the right to Francovich damages is removed because, of course, it's related to a breach of European Union law, and that would not be appropriate to continue in accordance with Amendment 43 after we have left the European Union. And it's quite clear in saying that there is no right in domestic law on or after exit date to damages in accordance with the rule in Francovich. And to that extent, it does deal with the issue raised in the context of Section 16 of the Interpretation Act 1978.
I'm taking it from what the noble and learned lord is saying that he accepts that there are existing rights to recover damages available in the British courts which the government wishes to remove. That's a breach of promise, isn't it?
Now, I wonder if the noble lord could exercise a small degree of patience while I just complete what I've got to say on this topic. But we can take as long as it takes. As I was saying, in terms of Schedule 1, paragraph 4, the right in domestic law to damages in accordance with the rule in Francovich is removed as at exit date. There is, of course, a proviso in Schedule 8, paragraph 27, in respect of claims for Francovich damages which have already been raised prior to exit date, the point that the noble and learned Lord Goldsmith made. The potential lacuna is this. There may be accrued rights as at exit date where no claim has been made. And we recognise that, and that was noted in the other place. And we are open to addressing that issue in order to ensure that those accrued rights are not removed by the application of paragraph 4 of Schedule 1. And that is something that, as I've indicated, we are prepared to look at because we are aware of the criticism which has been made about the potential removal of rights that have already accrued as at the exit date.
Grateful for the noble and learned Lord giving way. Do I take it from that he'll be bringing forward an amendment to correct this?
I'm obliged to the noble and learned friend. As I say, we are addressing that issue and we recognise the issue, and therefore in time for report we will be determining what our position is on that. I can't go further at this stage. I'm not going to commit to an amendment at this stage, but I'm making it perfectly clear that we recognise that there is a potential lacuna arising from the fact that where the claim has been made before Brexit date, it is continued. Where the claim has accrued but no claim has actually been made, it would be lost by this process. And we recognise that there is room for criticism of the legislation on that basis. So let me be absolutely clear about that. And it's in these circumstances that I recognise the force of the amendment proposed by the noble and learned Lord Goldsmith and the amendment proposed by Lord Carlile in order to address that issue. What I would take issue with is the scope of the amendment proposed by Lord Davies, which goes well beyond that and would maintain some sort of claim for Francovich damages in a context quite unrelated to our departure from the European Union. And that would not be appropriate. And I underline this. I mentioned earlier the limited number of cases in which Francovich damages have arisen. And that in itself would suggest that it might be a proportionate response to the amendments made by the noble and learned Lord and Lord Carlile to actually allow for claims that have accrued because they are few and they are potentially very few indeed. So I recognise that entirely. I'm not committing to an amendment at this stage, but I will make the position clearer by the time we reach report. In these circumstances, I would invite noble lords to withdraw these amendments.
The Lord sits down and we all go to bed. I'm very puzzled by his suggestion that there is a right to damages in judicial review currently, such that Francovich damages don't add anything. I mean, in what circumstances is the noble and learned Lord suggesting that there is a right to damages in judicial review, other than in the very rare cases where you can prove misfeasance in public office?
That is one example of where a claim for damages would arise in the context of a judicial review. And there are distinct circumstances in which Francovich damages will arise. But the noble Lord will himself recognise that the circumstances in which you can actually establish a basis of claim for Francovich damages are even rarer than those instances in which you can establish them in a domestic judicial review.
It is quite clear, I suggest to the noble and learned Lord, that damages under Francovich are provided in circumstances where you would not otherwise get damages because you cannot prove misfeasance, but you can prove that the breach is sufficiently serious and that the law was intended to confer a right to damages. And that's why I suggest to him that paragraph 4 is taking away something of value.
Well, in response to the noble Lord's observations, we are dealing in the context of Francovich, where the court has to be able to find that there has been a serious failure with regard to an EU obligation. And I would suggest that is not very far from the test of misfeasance in the context of judicial review.
My Lords, I'm very grateful to everybody who's taken part in this interesting debate. I think anybody who's listening in from the outside would be impressed that we are working hard on a very serious matter at quarter to 1 in the morning.
And not drinking cocoa.
I'm sorry, I missed that.
Not drinking cocoa.
And not drinking cocoa, indeed. Absolutely right. My Lords, I think, first of all, I must say, I think that noble Lord Keen is actually, noble and learned Lord Keen has actually misunderstood a number of things. One is, I think he's got it wrong on the issue of damages. I think that Lord Pannick Lord Pannick is at least representative in what he said of the great majority of legal opinion on this subject, and of the experience that any of us have had by our constituents or otherwise in this particular area of the law. The second thing is, I think it's misunderstood that part of the importance, a major part of the importance of Francovich, the Francovich system, if you like, Francovich jurisprudence, is that it is a potential deterrent to those who might be inclined to misgovern us, that people know that they're subject to this particular sanction if they do, and that has enormous effect. So it does, the fact that the power is used 25 times, it's not negligible, 28 times it was in this country, 300 and something times over the Union as a whole, doesn't mean to say that it's not without effect, or that this effect is limited to those occasions. It would be very naive to say that. This effect is created by the presence of this particular sanction, this particular means of redress for those who've been wronged in this particular way. I also don't think that the noble Lord is right in saying that the whole matter is Francovich not very important, because it only applies when there are serious issues, and I think that the principle, if I can put it in the way that language that I think that the noble Lord will understand, de minimis non curat rex, applies to everything really in the Roman law tradition anyway, and so it's not at all surprising that it applies to in this particular case. My Lords, I really want to leave the committee with complete clarity about this, and I think there are three quite separate issues here. One is, what do we do about people who have a claim or think they have a claim under the Francovich principle, and I continue to call it that, and it is overtaken by events because they haven't litigated before Brexit, or they're halfway through, or they believe they've got a claim but they actually haven't expressed their claim or put it in at all. What happens about them? Now that is important, because it may only be 3 or 4 people. We should always be concerned about justice for everybody. So I don't in any way denigrate people who have taken on a lot of time to talk about that particular subject. I think that's a perfectly respectable concern to have. But my concern isn't really with them. My concern is, in my mind, much more significant, and that is, going forward, do we have the Francovich principle or something like it in our own legal system, both to enshrine that principle that the state is subject to the law like everybody else, which I say is so important, and to make sure we do have that instrument of good government, which has a real deterrent effect on the behaviour of central government, local government, public corporations, and indeed the private sector. And that is very important to me. And I disagree with the noble lord when he says very strongly, the noble and learned lord, Lord Keen, when he says, well, the Francovich system doesn't make any sense when we've left the European Union, because there won't be such a thing as European law here. I think he's quite wrong about that. There will be retained law for decades, no doubt, until it's changed by statute. If it is changed by statute over that time, it's called retained law. It is exactly the same law. The difference may be that whereas you could litigate under it before Brexit, after Brexit you won't be able to litigate under it at all. That seems completely unreasonable. That is the loss of remedies, a loss of rights that we currently have in respect of exactly the same laws, because they are the same provisions in exactly the same wording, having exactly the same effect, whether they are today on the 25th of March, the European law, the same laws, the same wording on the 1st of April next year after we've left Brexit. That is what the whole principle of retained law, as I understand it. I think the noble and learned lord knows that. So it's my concern in this amendment to make sure that where the citizens of this country have current rights and protections, they should enjoy all of those after Brexit. I thought the government were in favour of that principle. We've heard earlier on from another minister, Lord Duncan, that he believes that is the case and favours that principle, and I think that principle is enormously important. Then there is a third issue, which I did raise, and I raised it deliberately, probably not the last time I shall raise it in this House, and that is that I think that actually the experience of Francovich is such that I believe it should be carried forward into the whole corpus of law in this country, Scots law and English law. So we continue to have these rights, we continue to have these remedies. I think there will be, I believe them to be, their jurisprudence in this case, to be a considerable advance of civilization in the European Union over the last 25 years. There have been many such advances. But I think if we're going to carry forward the assets that we take over, rather than throwing them away on Brexit, we should make sure we carry forward this one. That is not a matter for this bill. What is a matter for this bill is the second point I'm making, which is to make sure that in respect of retained law, the rights that currently exist will be carried through and will not be abolished. And between now and report stage, I hope that the government will think about that, and I would certainly welcome an opportunity to discuss the matter with them before we decide how we can take this matter further. In the circumstances, I beg leave to withdraw the amendment.
Is it your Lordship's pleasure that Amendment 43 be withdrawn? Amendment is by leave withdrawn. Amendment 44, Lord Goldsmith, not moved. Amendment 45, Lord Carlile, not moved. Amendments 46 and 47 have already been debated, not moved. The question is that Schedule 1 be the first schedule of the bill. As many as are of that opinion will say content. Contrary not content, the contents have it. In Clause 6, Amendment 48, Lord Carlile.
Moving this amendment, my lords, very briefly, can I say how grateful I am to the noble and learned lord for what he said earlier, which was well worth waiting up for, and indeed rather more stimulating than the cup of cocoa I referred to earlier. Having said that, I can see no point in prolonging the debate on these amendments, and therefore, if it's appropriate, I seek leave to withdraw them.
Now, the noble lord must move the amendment first before he can withdraw it. Amendment proposed in page 3, line 32, after court, insert except in relation to anything that happened before that day.
Draw it now, please.
They are the property of the committee until the noble lord obtains the permission of the committee. Is your Lordship's pleasure that Amendment 48 be withdrawn? Yes. Is by leave withdrawn.
My Lords, I beg to move that the House be now resumed.
The question is that the House be resumed. As many as are of that opinion will say content. Content. Contrary not content, the contents have it.
My Lords, I beg to move that the House do now adjourn.
That the House do now adjourn.